Swayam Prabha. Digital India. Educated India.
Dear students, in this class we will discuss about the vertical agreements, and in the last class we talked about horizontal agreements and what is prohibitive in nature under the competition law. And in this class we will discuss about another category of agreements which are known as vertical agreements, and the last class also I have mentioned about what are vertical agreements. And basically the vertical agreements are nothing but the enterprises work at different stages of production chain and at different manufacturing level or at the distribution level. At the same time, horizontal agreements at the same level and vertical agreements are at the different levels. That is the only differences. So, and also the per se rule is not applicable to the vertical agreements, and but per se rule is applicable to the horizontal agreements. So, the vertical agreements are, the question is whether they are causing appreciable adverse effect on competition is determined by the rule of reason. That means, rule of reason is also applicable to the vertical agreements, but it will depends upon if there is an appreciable adverse effect on competition, then only the vertical agreements are applicable. And what are these vertical agreements? And the vertical agreements are nothing but these at the different stages of level, we can divide it into different stages and or different categories of agreements. So, these are working at the same level. So, these vertical agreements they work at the different level, and which is actually the contravention of the certain the commodities affecting the market, and we will see that how these agreements affect the market. So, there must be an agreement amongst the enterprises or persons. So, like in any other combinations. So, the parties to such agreement must be at different stages. This is the second condition to fulfill the vertical agreement, and their level of production must be different, or they are in the chain or in respect of production, supply, distribution, storage, sale of price or trade or goods provision of services must be at different level. This is the second condition, and the agreeing parties must be at different markets. This is the third condition to fulfill the vertical agreements. And the agreement should cause or should be likely to cause an appreciable adverse effect on competition, which is mentioned under section 19 of the Indian Competition Act. Then this will be considered as a vertical agreement. Then again we can see that vertical agreement will be always evaluated based on the presumption of appreciable adverse effect on competition. But at the same time you can see that the resale price maintenance, and we will see the different categories of it starting from the tying agreements and has end up with the resale price maintenance. And so, we will see these agreements one by one. So, the categories of agreements were mentioned under section 3(4) of the Indian Competition Act, and the first one is the tying arrangement. So, tie-in arrangement is nothing but if there is an agreement requiring a purchaser of the goods as a condition of such purchase to purchase some other goods which the consumer does not want. So, that means, so the tie-in arrangement is an arrangement where I want to purchase something, but I will be forced to purchase something else also along with that particular product. That is the tie-in arrangement. Then the second category of agreement is the exclusive supply agreement. So, this includes the agreements restricting the purchaser in the course of his trade from acquiring or otherwise dealing in any goods or other than those of the seller or any other person. So, the distributor will be preventing from taking distribution agency of any other company. So, exclusive supply agreements. Thirdly, exclusive distribution agreement, this is similar to the supply agreement. So, which includes the agreement to limit, restrict, withhold, output, supply of goods, allocation of market or any market disposal or sale of goods. So, tying arrangement, exclusive supply agreement and exclusive distribution agreement is also considered as a vertical agreement. Then a refusal to deal, and refusal to deal is one of the another pernicious form of anti-competitive practice, that is which restricts. So, the agreements to restrict or likely to restrict the class or classes of persons whom goods are sold or from goods are bought. So, you agree that I am not going to sell to this particular class of persons, that is the refusal to deal. And the last form of vertical agreement is the resale price maintenance, which includes agreements or goods on condition that the prices to be changed on resale by the purchaser shall be the prices stipulated by the seller. That means, the resale price will be stipulated by the seller unless unless there is an agreement between these parties. So, resale price maintenance also is considered as a vertical agreement, which is distortive to the market. We will start with one by one. What is this tie-in arrangement? So, as I already told you, the tie-in arrangement which requires that a party to buy one product. So, more than one product he want to purchase it, but at the he will get it, he can purchase only it in addition to the input which he requires, he have to purchase another one. So, they tie the products, tying the products. So, tying the one product with another one, that is the tie-in arrangements. So, the purchase to goods, such purchase, the purchase some other goods, it is very simple that I do not want another product which I will be forced to purchase it, that is the tying agreement, which is the simile. And tying agreement, you can see that intending actually the purchaser or the purchaser of particular product required by the supplier to purchase some other product. So, even though I do not require that particular product, but I will be forced to purchase that particular product, so that then only I can get the services or I can get the product of another one. The famous case of the Microsoft media player case, which we will discuss it on later stage. So, if you want to purchase it the operating system, you want to purchase it the media player as well, and so you are forced to purchase some other product which you do not want it. So, that is the basically known as the tie-in arrangement. So, this we know that the product, it is how it is going to affect the market. Definitely it is going to affect the market, and it is directly affecting the consumer welfare, because I do not want to purchase a particular product which I am forced to purchase, because I want one product which is essential for me, but the other one is the tied product or service which is I do not want it actually, I am forced to purchase it that one. So, that means it is leads to unnecessary cost to me. So, it is distorting the market. So, these agreements are considered as considered to be distorting particular market, and there is a trade off between the parties. So, they try to capture the market through one product, and they want to sell, one company want to sell some of their other products which the consumer does not want. Then comes and also for this tying, and these companies use their market power as well. For example, as I already talked about the Microsoft, and Microsoft softwares, the operating systems and the Office, and they are holding more than 90% of the market, and they impose that you should purchase another product of us, then only you can get the operating system. And the market power, and here in this particular in Jefferson Parish Hospital case, definitely it is one of the US cases, and the court which saw that, and if whoever uses the hospital, whoever is availing the service of the hospital operating rooms, and they tied the product, what is their product? Their anesthesia service. So, if you want to use my operation theater, you must take the services, my the anesthesia service also you must take. So, they tied the anesthesia service along with the hospital operating rooms. So, this is actually tying. This was held to be per se illegal by the US court. So, even though the per se rule is not applicable to the vertical agreements, but the court uses this test and held that it is illegal per se. So, the tying is definitely is not always, but it can be pernicious to the market, distorting to the market, and which is has unnecessary burden on the consumer. So, it is anti-competitive in nature. I will go to the second one, that is the exclusive supply agreements. And exclusive supply agreements basically prohibits the downstream party in dealing with the products other than of that particular party. So, it means the competition, there is no competition, so that you are not going to take the dealership of somebody else. You are not going to deal with a particular competitive product of the upstream supplier. So, here the exclusive agreement restricting any manner the purchaser in the course of his trade from acquiring or otherwise dealing in any goods other than those of the seller or any other person. So, it means that you are restricting a particular seller to deal with your product only, not the competitor's product or anybody else's product. So, these exclusive supply agreements are also going to directly affect the particular market. So, and as I told you, this again this restriction, always these restrictions the upstream party is going to impose conditions on the downstream purchaser, but you can see that it is always a closed group. The downstream purchaser will be always a closed group, and then there can be as collusion as well on the downstream as well. For example, the next as I told you, the exclusive agreement thus always restrict, always put restrictions on the market, and so it is anti-competitive in nature. And exclusive distribution agreement. Exclusive distribution agreement is another form of which is distorting the market distortion, which you can find it anti-competitive in nature. So, here the exclusive distribution agreement, it is an arrangement between company grants exclusive rights to the producers or services to another company. So, here you can see that mostly single branding or single branding showrooms or exclusive territory rights, for example, the state distributors, and then single distributor, exclusive distributor, and he cannot take the distribution business of any competitive company or any other company. So, it will become exclusive distribution agreements. So, this also is to promote his own product or services to the customers, and the distributor is preventing from availing the services of anybody else, or the market power is limited by interbrand competition. So, if there is interbrand competition, then there will be competition in the market and the consumers will get a better products and better services, but this interbrand competition will be limited by these exclusive distribution agreements, and that it is anti-competitive in nature. And the main features which we can see is that which agreements to restrict or withhold the output or supply of goods or allocate any area, geographical area or market for the disposal of the sale of goods. And also we can see that this allocation, section 3(4) of the Competition Act, which says that allocate any area or market for the disposal of sale of the goods. This is the terminology which is used. So, the geographical distribution of goods is included in this, and the geographical distribution which includes, it can regional distribution or state distribution or specific the area can be demarcated by the upstream supplier always, which will affect the competition in the market. And then another form of anti-competitive practice is the refusal to deal, and refusal to deal with the customers or suppliers. So, this ultimately which is directly going to affect the market and say that I refuse to deal with you if you deal with my competitor. So, I put a condition that if you deal with my competitor, I refuse to deal with you. So, this is going to be ultimately affect the market at large. So, it is considered to be it's anti-competitive in nature. So, and in antitrust law, we can see that this refusal to deal is considered to be anti-competitive in nature, because there is every firm to have a duty to the public. Every firm have a duty to have their services to everybody, and you cannot refuse the services. And imposing additional obligations on the firm to do some business with its rival is it's not possible at all. So, the antitrust rules which look into this refusal to deal also is as a unreasonable restriction or unreasonable restriction which restrict competition in the market. So, refusal to deal is definitely in certain circumstances refuse to business with the competitors. For example, you cannot compel them to so we will see later on the Macromax and the Ericsson case in India. Can you really refuse to deal with your competitor? The answer is no. In a perfect competition market, you cannot refuse to deal with, you cannot refuse to license with anybody. So, and also we will discuss about the standard essential patents and the concept of standard essential patents, how it is emerged from this refusal to deal. And if a monopolist cannot refuse to sell a particular product or service to its competitors, and the here the monopolist is doing a business with the competitor, and the monopolist has legitimate business reasons for such policies. So, if you want to refuse, there must be very strong reasons to refuse such kind of services, otherwise it will be considered as anti-competitive in nature. And so, in some of the cases we can say that this, even though it is a vertical agreement and it is some of the activities are per se illegal. For example, restraint of trade, and restraint of trade, as you know that we were discussing in the last classes, that especially in the US, under the US law, restraint of trade is considered to be a felony. So, here but in Indian Competition Act it is not considered to be a felony at all. So, but the vertical agreements, as I told you earlier also, the per se rule is not applicable, but certain circumstances the court can declare it as the per se rule, especially when the refusal to deal. And if you look into one of these cases, and it is almost the same case which we discussed about the hospital case. In 2014, which the Indian Competition Commission has discussed about this particular case. So, here also the Excel Healthcare, the stockist for pharmaceuticals in Goa, and they were violating the CCI order, and they continued to control the supply, and also these this particular company is continued to control the supply of pharmaceuticals in Goa through a stipulation. All stockists in Goa must obtain a non-objection certificate from it, and this pressuring the pharmaceutical companies in not to supply or stockist with other than any other particular company. So, exclusive agreement. So, exclusive agreement is also considered to be distorting, market distorting, and considered to be anti-competitive in nature. And which we discussed about. So, this all the big pharmaceutical companies do this, they refuse to deal, and exclusive marketing rights they give, and also the distribution agreements which they give, because now the watchdog, the Competition Commission of India is there to look into this kind of violations. And so you can find a heavy fine will be imposed by the Competition Commission of India in such kind of cases, and whether it is in foreign jurisdictions or in the Indian jurisdictions. And the last the form of vertical agreement is the resale price maintenance. That the resale price maintenance is nothing but the manufacturers set the prices at which the retail shop person will sell his particular product, and there is no freedom to the retail shopper to have a competitive price in the market. So, and so the wholesale business as well as the retail business and the price maintenance, they fix the prices. So, this will be known as the resale price maintenance, and resale price maintenance also is considered to be is anti-competitive in nature. And here you can see the manufacturer, and through a system of distributors and to the retailers, and retailers agree for a resale price maintenance fixed by the manufacturer. So, the minimum retail price. So, no, it is actually it is the maximum retail price, but these companies fix the minimum retail price so that they can exploit the particular market, but this is considered to be exploitative in nature. And we can find number of cases also, whether it is in foreign markets or in the Indian markets, to resale price maintenance, and this is also usually the usual anti-competitive practices which is managed by the Indian companies as well. So, this is always the price fixing is also is within the purview of the competition law. And under 3(4) of the Indian Competition Act, all vertical restraint had to be is evaluated under the rule of reason. Then this anti-competitive nature can be established. And the resale price maintenance, which we already talked about this. And if it is cropped with these, we can look into the pro-competitive benefits. To what are the pro-competitive benefits in order to in order to calculate the whether it is per se it is illegal or not. So, if you can have all these practices without any harm to the competitive process in the market, but this I think this argument is not a valid argument, because all these practices have an anti-competitive effect on the market. Then how can you practice this without the affecting the competitive process in the market? Then again, sales support to the retailers extended by the manufacturers may not be exploited with the free riders. So, there is the connection between the seller and the company and the retailers. Specific programs always the company will say that the company will see that only their product is sold in the market. Then the question of free riding in the market is not going to happen. Then so full service retailers, and then product require retail service very rare, then incremental sales, all these are considered to be pro-competitive benefits. So, if you can if you can prove the pro-competitive benefits, then it will not be considered as anti-competitive in nature, but it is unlikely happen and very unlikely to happen to prove these pro-competitive the factors. So, you can find a number of other factors which you can find it. And then and also these resale price management usually induce the cartels as well. So, you can find a number of examples of the international vitamin cartel was one of the best example. So, and there is no mechanism to monitor these international cartels other than the territorial in nature. So, these cartel agreements, in order to control these cartel agreements, are also very difficult in nature. So, in this class, so we were trying to discuss about all the vertical agreements which is anti-competitive in nature and which we discussed at the different levels of market and different levels of competition. And so, combining horizontal agreements and vertical agreements, all the anti-competitive practices are distorting the market and thus anti-competitive in nature and violation of the competition provisions of each and every country, and the Indian Competition Act also is prohibited these kind of activities. So, we will stop here this particular class, the horizontal agreements and vertical agreements, and in the next class which we will talk about the abuse of dominant position. Thank you.